Welcome to the Personal Injury Law Show, viewers. And this week we're talking about surveillance. My name's Tony Carbone, lawyer of 25 plus years. On my left, John Karensis, lawyer of many years and superstar litigator.
Tony,
and Nadia, you're back again.
I am.
Welcome
Thanks.
back.
Thanks for having me. Thanks.
Yeah.
Welcome.
John, in the news, I've got this interesting case. It was this bullying and harassment case that was run in court, in the county court. It went for 10 days. And this fellow alleged he was working for IAS, which is a cleaning service at the airport. It's gone out of business now. But he says that his supervisor bullied him and harassed him, grabbed his
terrible.
head, pushed it between the aisles.
severe bullying.
No, definitely a case of bullying.
But it's groundbreaking, guys, because up until now, there's been very few successful psychological, psychiatric injury cases succeed. And what's a major problem, John, when you're dealing with these sorts of cases?
You need witnesses to prove your claim. In this case, it was a 10-day hearing before a judge of the County Court of Victoria and a jury of 6 peers, Tony. Very hard-fought case. Witnesses provided by the worker showing what the bullying was actually occurring.
Do you know what the real problem is, Nadia? The law talks about foreseeability, and what that means is this, that you've got to have complaints with the employer so that you can proceed and win with one of these cases, which is what happened in this case. But in most instances, people are scared to what? To complain.
Yeah, well, that's right. And people are also scared to be witness, I find. You know, if you've witnessed something, you know. Yeah. So you're saying without witnesses, it may have not gone
Oh, you've got
so
Buckley's
well?
chance, I reckon.
It's going to be very difficult. You need witnesses to prove your case, to help you prove your case.
It corroborates your testimony.
Of course, and you know my views on this, Tony. The plaintiff, the worker giving evidence, is pivotal. If he is not believed by the jury,
Oh, John, it just shows you've got a psychiatric injury, psychological injury, and if you can't give an account of a story,
That's right.
you're, according to John, you're practically...
See, some cases would be hard to even get one witness, but this case had 10 witnesses.
10 witnesses.
That's incredible.
It had 3 very, very good witnesses.
3 really good ones.
One of them was very aggressive, one was very softly spoken, and one broke down and started crying.
What, had they been bullied as well?
Yes.
they saw the events.
Perhaps.
They saw what was going on, and you had the medical evidence, a psychiatrist, the treating psychologist.
Anyway, look, we could go on this topic forever.
Oh, yes, but it was a great
we
decision.
We should try and get the plaintiff in here, John.
Great result. Jury came back with a verdict of $325,000.
Which I think was light.
Huge.
No,
Do you
I
think it's
it was
light?
Yep.
But for bullying...
Pain and suffering, they only gave him $100,000. The guy's 53 years of age. Does that mean...
The worker will never work again, Nadia.
The sad thing about it is that the guy's 53 years of age, the plaintiff, and it just shows you, because you can't visualise depression and psychiatric injuries,
It's not a physical
they gave him
injury.
$100,000. If it had been a back injury, John, what would they give him?
$350.
There you go. 250 to 350, I reckon.
Yeah.
So,
Well, it puts
anyway,
it out there, puts a bullying case
It
out
does,
there.
it does.
Any
And
more to
bullying
come,
is a
perhaps.
very topical topic, isn't it, Tony?
And let's hope WorkCover take it more seriously from now on, because up until now, in fact, in that case, they said he made a mountain out of a molehill.
They're the words they used.
Well, in that particular case, there were repeated attempts to settle the matter. It couldn't occur. WorkCover did
John,
not want to settle the matter. The matter ran for 10 days to
I
get
can
a
see you're very
verdict.
passionate about this topic, but let's get on to surveillance because time's starting to fly. Viewers, with surveillance, in simple language, you have an injury, the insurer will get investigators to come out there and spy on you.
And so
They'll
they should.
literally spy on you. What do you mean they should?
They should. If someone's got an injury, how else are you going to prove it?
John, you got a back injury, right? What's a
Put surveillance on
investigator
them.
going to do?
Well, what the Victorian WorkCover Authority will employ, they employ investigators to follow the injured worker around once a claim is made, particularly when a serious injury application is lodged, to try and catch out the injured worker, to try and show that you're not acting in the way that you say you can.
Inconsistencies, in other words.
I don't think, do you really think it's trying to catch them out? It's really just seeing if they do have a serious injury. So you could be, by saying catching out, it sounds like
I
they're
think
really trying
that-
to catch them doing something they're not meant to be doing.
Well, John, I'll throw this at you. Do you think they set them up? You know, they...
That has occurred. That has
Oh,
occurred.
I
I've seen that
know.
with my own experience.
But you know, how do you distinguish between the ones that are really serious and the ones that aren't really
Look,
serious?
in
Put
effect, they're
surveillance on
assessing
them.
The
Correct,
medical
Nadia.
evidence will distinguish that, Nadia.
Yes, but what about those that are touch and go, borderline serious
John, I'll tell you what
injury?
Nadia's coming at. Nadia's basically saying the only way you can work out whether these people are telling the truth and they've got these injuries is if you follow them around to see if they're being consistent with what their complaints are with doctors, and how they conduct
True.
themselves in
Tony-
everyday life.
And I
Tony-
don't think they follow them around all the time. It's a
But
couple
they
of days.
do. That's the problem. In a lot of
Couple of days
cases,
at a time.
no, in a lot of cases, there is 40 hours of video surveillance on a particular worker. Yet in the courtroom, they show 2 minutes.
So, John,
Where
what
the
you're
person's-
saying, what
2
you're
minutes, which don't look good to the injured worker, and that's used against the worker.
But I think surveillance
Out
has a
of
role,
40
John.
hours, Nadia.
It has a role though. And I think the insurers, I mean, that's what they need to do.
Can I just keep? I know this is you guys are getting hot under the collar here. The investigators are governed by the Private Security Act 2004, which means they've got to get a certificate 3 in investigative services or higher. Now, so they've got to actually get out there and study. They just can't go rock up and
not
say,
anyone can do
I'm
it."
following someone. Now, would it surprise
these
you, Nadia, that there's 25,000 licence holding private investigators in Australia?
Well,
25,000.
But there's a lot of injured people too. We need those. We need those people out
How many claims do you reckon there are in Victoria? John?
20,000 a year.
20,000
there are
claims.
20,000 work cover claims a year.
But they may not all work full time, Tony.
Look, can I?
Well, there's a lot of work injuries.
I'd imagine they're working around the clock because you catch people out at all hours. You get them at night, you get them in the morning. They sleep in their cars. I actually had an experience once where one of my clients came up to me and said he was on a farm and the investigator was sleeping in his car. He went and knocked on the window and said, "Would you like 1 or 2 sugars in your coffee?" And the guy was startled, you know. It's just absolutely astounding. It really
Look,
was.
I can understand
Exactly.
the humanistic side of things. You know, no one wants to know that they're being videotaped.
It's an invasion of privacy.
It can be.
Can I go to a
but it's
case just to
important.
make it interesting for the viewers? I know that you guys
Totally.
are hot. There's a case of Zato and Ivanchik. This plaintiff had a car accident, and he said that due to the injuries sustained in the accident, he had soft tissue, psychological injuries, couldn't work, couldn't cut the lawns, couldn't attend to the garden, couldn't swat. He said he couldn't do a lot of things. The word couldn't's a problem, isn't it, John?
Well, you need to show a degree of exactly what you can do and what you can't do.
He shouldn't say he couldn't do anything. He should say have
has
difficulty
doing something.
certain
The
things.
gardening has difficulty driving. I mean, it just depends on how he approached his affidavit.
Tony, what happened?
Anyway, prior to the film being shown to the insurance company, look, why don't we come back to this? I think we've got to go to a sponsors break. So viewers, please don't go away. Stay tuned because we'll be back to let you know what happened in this case. Thank you.